Have you ever felt totally locked out of the justice system just because you couldn't afford the cover charge? Well, what if I told you there's a totally legal, money-saving process right here in Georgia designed to literally unlock those courthouse doors for you? Welcome to The Explainer. Today, we're going to show you exactly how to navigate this system. Look, if you're staring down a lawsuit, going through a messy divorce, or even just trying to get a name change, the absolute last thing you need is the paralyzing financial anxiety of court costs you just can't scrape together. It can honestly feel like the whole system is rigged against anyone without deep pockets. But here's the good news. There is a solution built right into Georgia law, and it's a tool anyone in the state might need to use at some point. Okay, let's look at our roadmap for today. First, what are fee waivers? Second, who actually qualifies? Third, the step-by-step process. Fourth, avoiding common traps. Fifth, where to find help. And finally, some crucial warnings and our conclusion. All right, jumping right into Section 1. What are fee waivers? Let's lay the groundwork here. So where does this right actually come from? Well, it comes straight from the official code of Georgia Annotated, specifically Section 9-15-2. This statute basically says that any party, and I mean whether you're the one suing or the one being sued, in any court action across the state can request a waiver of standard deposits, fees, and litigation costs. The main catch? You have to show severe financial hardship. You're going to hear this called in forma pauperis or a pauper's affidavit. Let's just toss that intimidating Latin jargon out the window for a second. In plain English, it just means you're giving the court a sworn declaration that you literally cannot afford to pay. This waiver is huge. It can cover initial filing fees, sheriff service fees, and even mediation costs in places like Gwinnett County. And the best part, filing this affidavit doesn't negatively impact the judge's view of your actual case one bit. Section 2. Who actually qualifies? Because it all sounds great in theory, but how poor is poor enough? The answer to that actually depends entirely on which court you're standing in. In Georgia's civil courts, like superior or state courts, judges look at this on a case-by-case basis. They're typically checking if your income aligns with about 125 to 150% of the federal poverty guidelines. But, and this is a big but, if you are in federal bankruptcy court, the rules are incredibly strict. Federal law says your household income must be strictly less than 150% of the U.S. Health and Human Services poverty guidelines. And on top of that, you have to prove you can't even pay the fee in installments. There's really no wiggle room there. Moving right along to Section 3, the step-by-step process. Let's talk about how you actually get this done. You can't just stroll into the clerk's office and say, "Hey, I'm broke." You've got to prove it. Local courts have very strict standing orders. Take DeKalb County, for example. There, you've got to hand over a copy of your most recent bank statement plus copies of your 2 most recent paychecks or disability checks. Actually, scratch that. If you don't have a bank statement, there's a workaround. The court will take a combo of a utility bill, a cable bill, and a cell phone bill to verify your financial footprint. But wait, before you just hand over a massive stock of your personal bills, listen to me. You absolutely have to protect your identity. Remember, court records often become public. The rules explicitly tell you to strike out your full date of birth, your social security number, and basically everything except the last 4 digits of any account numbers on those documents. Now, here's a really critical distinction in how you physically file this paperwork. Georgia courts have aggressively moved toward mandatory electronic filing, using systems like Odyssey eFile GA. But that mandate, it's really for attorneys. If you are a pro se litigant, which just means you're representing yourself, you currently cannot use the e-filing system for this. You're stuck with the traditional paper process. You've got to submit your pauper's affidavit and initial pleadings either by mailing them in or showing up in person at the clerk's office. Okay, Section 4. Avoiding common traps. Because while the paperwork looks easy, there are hidden landmines here that ruin applications every single day. You need to pay incredibly close attention to this next part. Your affidavit absolutely must state that you are unable to pay costs because of his poverty or because of her poverty. Why are those magic words so absolutely crucial? Because Georgia appellate courts don't mess around with this. If you just write, "Hey, I don't have the money," or "I'm unemployed right now," they will toss it. Longstanding case law literally says that missing this exact statutory phrasing is a fatal defect that ruins your entire affidavit. And that's not the only trap out there. Let's run through a few more. First, joint filings. If you and someone else are suing together, you can't just share one affidavit. Nope, every single person needs their own separate form. Second, the bankruptcy trap.
If you somehow scrounged up the cash to pay a private attorney, the court is almost definitely going to deny your fee waiver. Their logic? If you can afford a lawyer, you can afford the court fees. And finally, keep in mind you generally cannot use poverty affidavits to bypass fees for emergency filings.
Section 5. Where to find help. Because if all these strict rules are making your head spin, just take a breath.
You don't have to do this alone. Georgia actually has an amazing safety net of nonprofits dedicated entirely to helping low-income folks get access to the courts. If you're in Fulton, Clayton, Cobb, Gwinnett, or DeKalb counties, Atlanta Legal Aid is your go-to. Anywhere else in Georgia, call the Georgia Legal Services Program. And if you're over 60, there's Georgia Senior Legal Aid. These guys hold screening clinics and literally give you the exact automated forms you need to make sure your affidavit is perfect. I highly suggest hitting pause on this explainer right now and taking these numbers down.
All right, we're heading into Section 6, Crucial Warnings and Conclusion. Just some final legal housekeeping before we wrap up.
Look, when you sign one of these affidavits, you are swearing an oath under penalty of perjury. The opposing lawyer or even the judge can issue a traverse. That's just a fancy word for formally challenging whether you're telling the truth about being broke. If the court decides you actually can afford the fees, you'll be ordered to pay them, and your case could get thrown out if you don't. But worse than that, lying on a sworn document can literally carry felony warnings in certain Georgia jurisdictions. Complete, absolute honesty is non-negotiable here.
And speaking of legal housekeeping, here is our professional disclaimer. The content in this explainer is meant for informational purposes only. It is absolutely not legal advice. If you need specific guidance for your unique situation, definitely consult with an attorney or reach out to those awesome legal aid resources we just talked about.
You know, the justice system is supposed to serve everyone, not just the people who can easily write a check at the clerk's window. Yes, the paperwork can seem super intimidating at first glance, but understanding the exact terminology, knowing what evidence you need, and leveraging the free resources out there, that completely tears down those financial barriers. Financial hardship shouldn't lock you out of the courts. So, armed with this knowledge, are you ready to claim your rightful access to the justice system?